Viewers, welcome back to the Personal Injury Law Show. Tonight's topic of discussion is about exclusion clauses and waivers in the recreational context. With us, we've got Alvin Achariya, a personal injury lawyer and insurance law. How are you, Alvin?
Fine, thank you, Tony, and good evening to our viewers, and good evening, Nunzio.
Alvin.
Nunz, tell us a bit about what the topic is all about tonight.
Oh, look, I think this is a topic that's close to everybody's heart in the sense that we've all, I suppose, gone through it. You know, when you go to a go-kart track or when you go to a theme park and, you know, they put something in front of you, they say, please sign this this waiver to say that, you know, we're excluded from all liability. That's really what we're talking about tonight. Can you get over that exclusion clauses? What's the basis to do so? And in what context can that happen? So it's a real interesting topic.
Name some of the events that we're talking about here.
It's a number of daily activities we do. I mean, recreational activities, including abseiling, go-karting, bungee jumping, whitewater rafting, four-wheel drives, and etc.
So, rock climbing, artificial climbing of structures. It's never ending. Bushwalking, mountain bike, riding, snorkeling, canoeing and kayaking. In fact, someone died the other day snorkeling.
That's right.
And scuba diving.
And look, and that's why these companies that run these type of recreational activities, they're always worried about their liability that attaches to these type of activities. Hence, you know, they try and, I suppose, get over that liability of putting exclusion clauses, and that's what tonight's about, Tony.
Okay. And Alvin, how often do you think the person that engages in one of these activities actually reads the document before they sign?
Very rarely. Even my example, I was going on a tour recently, paperwork sent to me, I just signed blindly because you still want to go ahead with the activity. So how often do you take care of that or note of that? You don't.
Anyway, that becomes very important because of a case law. Nunzio, there's a raft of legislation dealing with these issues, isn't there?
Yeah, there is, Tony. You said both federally based and state based. You've got the Consumer Law Act, which is a Commonwealth Act. Then you've also got the Wrongs Act, then the Consumer Law Act and Fair Trading Act in Victoria. So there's so much legislation on this that it's a bit of a minefield at times, but we'll try and, I suppose, simplify for the viewers.
But Alvin, the legislation's reasonably consistent with each other.
They all have the same overriding theme. The starting off point is, in normal instances, a supplier of goods and services cannot contract out of their liability. However, in the event of a recreational activity, which you just mentioned, the number of items mentioned before, they can contract out. They can. However, in terms of negligence, if it's gross negligence or any reckless behaviour on their part, they're still liable.
Okay. Sorry, just step back. So if you can't contract out of supply of services, what does that mean for the viewers? What are they
was going
referring
to
to?
ask you that question.
Well, the way I read that is things like, you know, you go to, you know, your gardener comes over to your house and, I suppose mows your lawn, but obviously they do something in, I suppose, a negligent manner that you sustain injury, or that you can sue them. But recreational activities are a little bit different in the sense that you're, I suppose, exerting some physical activity in that regard.
Yeah. They are risky events, hence the reason why the organisers, they try to put in a clause to avoid any liability.
Okay. What's gross negligence mean?
Look, it's hard to define. I think they've tried to define it in these acts, but it's basically reckless disregard. Tony, you and I were talking about this before. If you go to a go-kart track and I suppose the occupier of the premises or the business is aware that a go-kart that you've been provided is damaged and may cause injury, and they provide that to you, well, I would have thought that's gross negligence or reckless disregard for, you know, someone's safety.
So in other words, if someone provides you with faulty equipment, that is belligerent and gross negligence, isn't it, Alvin?
In my view, I think there's a further limit to it. What they have to be basically is aware of, that they haven't provided you with the equipment. They know very well that it's not safe, yet they continue with that act. I think that's where the gross negligence lies.
Okay. Now let's go to the first case. There's a case of Le Mans Grand Prix Circuits Proprietary Limited and Iladius. 1998 decision. This is a case where a fellow got injured in a go-kart. What happened in that case, Nunzio?
Look, the main, I suppose, theme out of this case is that the court found that even though he'd signed a waiver of some sort, but I think it was marked more for advertising purposes, that it didn't hold up and that he could sue for his damage.
So, Alvin, he signed a document without reading it. Is that correct?
It was very misleading. He was in a rush, from what I understand. They gave him paperwork, pretty much saying it's advertising material. He thought it was a registration paper. I signed the registration. I can go in and then take part in the activity. He just signed it away without really knowing. obviously in that instance, the court found that the exclusions clause or the indemnity clause did not apply, hence the plaintiff succeeded in that case.
So in effect, he didn't know what he was signing. Is that correct, Nunzio?
No, he didn't. One, he was in a rush. Two, he actually said it was marked more for advertising or marketing purposes, so it was misleading in a way. And three, he said, like I think a lot of us do, we just sign it, we want to get involved in activity, you move on.
Now, viewers, this is where you have to pay attention. There's been a subsequent decision post that last case of Toll and Alpha Farm, which is a High Court decision. What's the significance of that one, Nunzio?
Look, that's good law now, in the sense that it is the current law that stands up, and basically that says that even if you've signed a document, we're aware of what you're signing, what's contained in that document, too late, you've basically accepted, I suppose, what you've signed and what's been put in front of you. So it basically overturned that last decision that we spoke about.
So in effect, Alvin, just to put it in a nutshell for the viewers, if you sign a document, you must read it.
Yes, however, to give protection to consumers, what the governments have done, both state and federally, they have made certain legislation changes where essentially the supplier of services has a duty to basically forewarn you or have signings, so at least brings to your attention that there's some clauses. Even if you haven't read that, you signed that, you are excluded. However, the next limit is, as we've talked about, the overriding theme is that if there's any gross negligence, then you could still succeed.
Okay, that takes us to the next case. There's a case of Insight Vacations and Young. It's a 2011 decision. Tell us the facts of that one, Nuns.
This is a lady who was injured on a tour bus overseas somewhere in Europe. Was standing up to get her luggage on her bus, and I think the bus suddenly braked and she sustained injury. And the tour company was trying to rely on exclusion clauses, says that they're, I suppose, excluded from any liability attached to you sitting in a seat not wearing a seatbelt.
Well, she was supposed to, the exclusion clause said that at all times you must be sitting in your seat, Alvin, with a seatbelt on. Is that correct?
That's where I think they got down. The exclusion clause was specific regarding that. You have to be seated and wearing a seatbelt. In this instance, the plaintiff was injured whilst not seated. She got out of her seat, was trying to get something out over the overhead luggage cabin, and that's when there was a sudden jolt. She sustained injuries. She sued them.
Viewers, we'll come back to the result of that decision just after a break, so please stay tuned.